Hello, I'm David Thompson, Vice President of Public Policy for the National Council of Nonprofits. We are delighted that more than 2,300 people have signed, nonprofit professionals have registered for this event, for this presentation. The new law on COVID-19, paid leave, and back to school, what nonprofit employers need to know to comply. Our purpose for doing this program is to promote compliance, clarity, and fairness. We have two terrific speakers who are going to ensure that we are all better prepared to comply with the law and apply it fairly. To us, it's vital that charitable nonprofit employers are model employers. Next slide, please. This program is presented to you by the networks of the National Council of Nonprofits. You can see who we are and where we are by the different logos on the screen. Next slide, please. I am honored to introduce our two speakers. Helen Applewhite is currently the Director of the Division of Family and Medical Leave Section, or Section 14C, and other labor standards. The division's responsibility include developing policy and procedures related to the enforcement of the Families First Coronavirus Response Act, the key law related to the paid leave provision. Ms. Applewhite has over 25 years of experience with the Department of Labor, beginning as an investigator covering West Virginia and Virginia. That will be a West Virginia accent for those of you who are keeping track. She has worked with the division's national office in DC since 2001, where she now directs the small staff that's providing subject matter expertise on the application of the FMLA, the Families First Act, and other important laws. Also speaking today is Christine Schott. She is currently the Senior Advisor to the Division of FMLA, Section 14C, and other labor standards. During her more than 25 years with the Wage and Hour Division, she has worked as an investigator, a manager, and regional strategic planning coordinator. Christine is a native of Lafayette, Louisiana, and is currently based here in DC. Change slide, please. Helen, I'll turn it over to you.
Thanks, Dave. I thank you for inviting us to speak today on this really important topic, and thank all of you for attending, and we look forward to your questions as we go through this presentation, and we'll try to leave room for addressing additional questions at the end of the presentation as well. We're going to provide an overview of the Families First Coronavirus Response Act, or FFCRA. Some people call it FECRA. The law was acted in response, as you know, to the COVID-19 public health emergency, and we want to give you a good overview of its provisions today. Next slide. Okay, I do have to always say that the presentation is intended as general information. It does not carry the force of legal opinion. You always have to look to the Federal Register or the Code of Federal Regulations for the official source of regulatory information published by the department. That being said, we promise to tell you the truth. Next slide. The FFCRA was signed into law on March 18th of 2020. And it has two primary provisions that the Wage and Hour Division enforces. That includes the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. These acts are similar, but there are some important differences between the two. So when we're talking about both acts, or things that are common to both acts, we'll generally refer to them as the FFCRA, or sometimes the Coronavirus Response Act. When we're talking about one specific act, we'll identify that act. We may use the phrase paid sick leave when we're referring to leave under the Emergency Paid Sick Leave Act provisions of the FFCRA, or expanded family and medical leave when we're talking about the Emergency Family and Medical Leave Expansion Act provisions of that act. So the FFCRA was, as I said, signed into law March 18th, and it's effective as of April the 1st, 2020. It expires on December 31st of this year. The provisions of the FFCRA are not retroactive. So if an employer closed a work site before April 1st, then employees at that work site would not be entitled to any benefits under the FFCRA. And that's true whether the employer closed the work site for lack of business or because it was required to close pursuant to a federal, state, or other local directive. And it's also true if the employer is open, but an employee was furloughed. In addition, as I'm sure you all are aware, on September 11th, the Wage and Hour Division also announced revisions to regulations that implement the paid sick leave and expanded family and medical leave provisions of the FFCRA. The revised rule clarifies workers' rights and employers' responsibilities regarding FFCRA paid leave. The rule was issued in light of the U.S. District Court for the Southern District of New York's August 3rd, 2020 decision, which invalidated certain portions of those regulations. So the revisions allow us to enforce the critical legal protections for millions of workers fully and fairly. The revised regulations, the explanations about them in text became effective immediately upon publication in the Federal Register, which was on September 16th. That means they're effective from September 16th, 2020 through the expiration of the FFCRA's paid leave provisions on December 31st of this year. Okay, next slide, please. Okay, so today we're going to give you general information and cover all of these topical areas, looking at the coverage, who's covered, what employees are entitled, the qualifying reasons for leave, amount of pay, duration of leave, etc. So we'll try to cover it all and then focus in on some particular areas. Next slide. So starting with coverage. Private employers with fewer than 500 employees are covered by the FFCRA. If a private sector employer has 500 or more employees, they are not covered by the FFCRA. There are also provisions for certain businesses with fewer than 50 employees who may be exempt from some of the requirements of the Act. And we'll talk more about this small business exemption minutes from now on one of the other slides. Employees of the federal government, state, local government employees, similar government units are also generally entitled to paid sick leave. Additionally, employees of state, local, and similar government units are entitled to leave under the Emergency Family and Medical Leave Expansion Act provisions if they meet certain eligibility requirements. And I'm not going to spend too much time on the federal government employees for this presentation, but basically the provisions are that for private employers, if you have fewer than 500 employees, then you would be covered by the FFCRA. And that's true whether you are a nonprofit or if you were a for-profit business. Next slide. So then we look at how employees are counted for purposes of determining that coverage. And for the private sector employer, you're covered if you have fewer than 500 employees at the time that the employee's leave is to be taken. The employee count includes full-time and part-time employees within the United States, which would include any state and the District of Columbia or any territory or possession of the United States. You should include employees who are on leave. When you're making the determination, you look at employees on leave. You look at temporary employees who are jointly employed by the employer, regardless of whether they're maintained on your payroll or someone else's payroll. It could include day laborers supplied by a temporary agency as well. All of those will be counted in determining whether you have fewer than 500 employees. Workers who are independent contractors rather than employees would not be counted for that employee threshold. Okay, so next slide. I want to talk a little bit about that small business exemption that I mentioned and just kind of get that under our belts as well. Small businesses with fewer than 50 employees may be exempt from the requirements of the FFCRA, but only those specific to the employee's need to care for a child whose school or place of care is closed or whose child care provider is unavailable due to COVID-19 precautions, and only when the imposition of such requirements would jeopardize the viability of the business as a going concern. So that's the statutory requirements for that small business exemption. Again, it's limited to that one specific leave reason, and only when providing the leave would jeopardize the viability of the business. There's no process to apply for the exemption. Unless requested, the employer doesn't need to provide anything to the Department of Labor or the division. What you would need to do is document and maintain appropriate records to demonstrate that you qualify for the exemption. There are specific ways that you would need to establish that that the leave would jeopardize the viability. One is if providing leave would result in expenses and financial obligations exceeding the available business revenues and would cause the small business to cease operating at a minimal capacity. Two is if the employee's absence would entail a substantial risk to the financial health or operational capabilities of the business because of the employee's specialized skills, knowledge of the business, or responsibilities. Or three, if there's insufficient employees able, willing, and qualified at the time and place needed to perform the labor or services provided by the employee, and these labor or services are needed for the business to operate again at a minimal capacity. So those are the criteria that you would look at in order to determine whether a small business exemption would apply in a specific scenario. Next, let's go on to the next slide. Okay, and here I want to spend just a little bit more time covering some of the exemptions that are available under the FFCRA. So covered employers of any size are permitted to exclude healthcare providers and emergency responders from the FFCRA leave entitlements. You may, but you're not required to exclude these employees from any of these leave entitlements. So for purposes of defining the set of employees who may be excluded from taking paid sick leave or expanded family medical leave under the FFCRA, a healthcare provider is defined to include two groups. And this is information that is based on the new regulations that were revised and published on September 16th. The first group of employees is based on the existing definition of a healthcare provider under the FMLA, and the FMLA regulations can be found at 29 CFR 825. The specific provisions defining healthcare provider for FMLA purposes are found at 825.102 and 825.125. This group includes anyone who is a licensed doctor of medicine, a nurse practitioner, or other healthcare provider that's permitted to issue a certification for purposes of leave under the FMLA for a serious health condition. The second group of employees who may be healthcare providers is any other person who is employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care, and if these services were not provided, it would adversely impact patient care. So this group includes employees who provide direct diagnostic, preventative treatment, or other patient care services, such as nurses, nurse assistants, and medical technicians. It would also include employees who directly assist or are supervised by a direct provider of diagnostic, preventative treatment, or other patient care services. Employees who do not directly provide healthcare services to a patient, but who are otherwise integrated into and necessary to the provision of those services. For example, a laboratory technician who processes medical test results to aid in the diagnosis and treatment of a health condition would also be considered healthcare providers under this definition. We also have an exemption under FFCRA that the employer can apply where an employee is an emergency responder. The definition of emergency responder is related to the employer's rights under FFCRA is broadly defined, and it would include anyone necessary for transport care, health care, comfort, and nutrition of such patients or others needed for the response to COVID-19. It also includes military or National Guard, law enforcement officers, correctional institution personnel, firefighters, emergency medical services personnel, physicians, nurses, public health personnel, EMTs and paramedics, emergency management personnel, 911 operators, public works personnel, and persons with skills or training in operating specialized equipment or other skills needed to provide aid in a declared emergency. So again, the definition is broad, but it is an exemption that would be based on the employee claiming that exemption under the FFCRA. I want to go on to the next slide, and then I think, David, it may be helpful if we pause. I don't know if there's any questions that you want to bring in at this point. I will say before we move on, though, that we will be addressing some more detail about both the paid leave provisions and the expanded family medical leave provisions in the next two sections. So the FFCRA requires that the employer post information about FFCRA conspicuously at the workplace where employees can see it. You can satisfy this requirement by posting the notice electronically or by directly mailing or emailing the notice to employees. It's not required to translate the poster. It doesn't have to be visible to job applicants, but not posting would be a violation of the FFCRA. And our next section, if you want to...
Let us ask some quick questions. I don't know if Tiffany's prepared some. Tiffany Gorley-Carter is also on the line. She's with in our Washington office. There have been a bunch of questions so far. Let me just kind of boil a couple of them down into counting questions. When, you may have said this, but when do you determine whether you have more or less than 500? Is that on April 1st, or is that a moving target?
It's a moving target. It's based on when the individual's leave is needed. And Christine, also, we're lucky to have Christine Schott with us today as well. She's a senior, as Dave introduced her, she's a senior advisor, which means in effect that she's been very close to the ground throughout the application of FFCRA since it was enacted. So Christine, certainly feel free to jump in at any time.
Okay. So it's a moving target. If you had 1,000 employees in March and you've laid off and now you're down to 400, does that mean that it does apply now for someone who is seeking leave?
Right. It's going to follow the time the employee's leave is to be taken. That's the time that you would count to see if you're covered.
Terrific. Thank you. Are we talking full-time equivalents or head count?
It's a head count. So it doesn't matter if the employee is full or part-time, and it doesn't matter if the employee is currently on the schedule or on leave. So you would count all the employees. Okay.
A lot of questions about specific job duties and so forth. If you were there was the emergency exemption, or for emergency responder type of thing. If your nonprofit is an emergency shelter, does that automatically fit into the emergency category, or are there more details that need, or more things?
I don't think that, I think that's a good question. And I think that for any exemption application questions, we're obviously for the course of this presentation, we're not going to be able to give you kind of yes, no, thumbs up, thumb down type of answers for specific scenarios. But that being said, we do have some very helpful resources and information available on our website, and we'll make sure that we share that link with you that can provide some additional information, including all of the, I know what I talked through in terms of the emergency responders specifically.
Mm-hmm.
There's a lot of information encompassed within that and a lot of named types of work. That being said, in any situation, you're looking at whether we encourage employers of all types to apply the exemptions judiciously based on your particular circumstances. You would need to know that the individual qualifies for the exemption before you could apply that exemption, but you're also not required to apply the exemption, and you are looking at it on an individual basis. And Christine, I don't know if there's anything you want to add to that.
Right. I would just reiterate then, just as general guidance, that the emergency responder definitions for purposes of the exemption includes, but it's not limited to, military or National Guard, law enforcement, correctional institution personnel, firefighters, emergency medical services personnel, physicians, nurses, public health personnel, emergency medical technicians, paramedics, emergency management personnel, 911 operators, child welfare workers and service providers, public works personnel, and persons with skills or training and operating specialized equipment or other skills needed to provide aid in a declared emergency, as well as individuals who work for such facilities employing these individuals. So like Helen said, I think it would, it's going to depend on what the particular facts are in each situation to see whether the person's job falls into one of these categories. And I did want to take, I think, in response to this one and a couple of other questions that are in the chat, I did want to let people know for some of the very specific questions, particularly I saw that there was a question about someone who was seeking leave. I did want to let you know to be sure to reach out to your local district office if you have a very particular question. You can contact Wage and Hour by calling. You can find your local office by calling 1-866-4-US-WAGE. That's 1-866-487-9243 to get to your local office. So if you have a specific question, particularly if it concerns an immediate need for leave, your best bet is to speak with somebody at one of our local offices.
That is terrific. We have, I think Helen said one of those questions was a particularly good question. We have literally hundreds of very good questions. So we better let you move on to the next section. Thank you.
Great, and I think, so I'm going to take the next section here on emergency paid sick leave, and we can go right to the next slide. And one of the, and let me say, I think there are several questions in the chat that have come up that I think we're going to address in this section. So again, the Families First Coronavirus Response Act, there are two sections or two provisions that Wage and Hour is enforcing. One is the Emergency Paid Sick Leave Act provisions. And so these provisions entitle employees of covered employers to take job-protected paid sick leave for up to 80 hours over a 2-week period for various reasons related to COVID-19. Along with the entitlement to the leave, employees are entitled to the continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. So the only requirement for an employee to be eligible for this leave is that they're working for a covered employer. Also, I think there was a question in the chat about asking about the furlough, if an employee was furloughed before April 1st. And in the beginning of the presentation, Helen mentioned that the law was not effective until April 1st. So if a business shut down prior to April 1st, there would not be an entitlement to leave. On the other hand, if a business is reopened and you have a current employee, if the employer is covered in the private sector, and that's an employer with fewer than 500 employees, the employer is covered, the employee can be eligible if they're open and they're scheduled to work and entitled to leave. Next slide, please. So the eligibility, again, is pretty simple. If the employee is working for the employer for at least 1 day, from the first day the employee works, they're eligible potentially for the paid sick leave. So full and part-time employees are covered, are both covered. Next slide, please. So there are 6 reasons that an employee can qualify to use the paid sick leave under the FFCRA. The first one is that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. The second is that an employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. And the third would be the employee is experiencing COVID-19 symptoms and they're seeking a medical diagnosis. And for each of these reasons, the employee is going to be entitled to his or her full regular rate of pay for up to a 2-week period and the equivalent of up to 80 hours. Now, an employee, though, in some of these circumstances might be able to perform work from home. They may be able to telework. And if the employee is able to work or telework, even then the paid sick leave is not available for the time that the employee is able to work. Okay, next slide. Okay, so that's the first 3 reasons. So the second group, let's start with reason 4, that the employee is caring for someone subject to a federal, state, or local quarantine or isolation order related to COVID-19. Or the employee's been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So under reason 4, the employee, rather than the employee being the one that's subject to the quarantine order or isolation order, the employee is caring for an individual who is subject to a federal, state, or local quarantine or isolation order, or has been advised by a healthcare provider to self-quarantine. The 5th reason is that the employee is needed to provide care for his or her child whose school or place of care is closed or whose child care provider is unavailable due to COVID-19 precautions. This applies even if the school is offering remote virtual classes. And we're going to talk more about this particular reason because the expanded family and medical leave under the FFCRA is going to cover this same reason for leave. Lastly, there is a reason 6, and this would be if the employee is experiencing a substantially similar condition as specified by the Secretary of the U.S. Department of Health and Human Services. But to date, we've not been notified that a similar condition has been specified. So there's currently no reason 6 that we need to that would come into play. Next slide, please. So again, the paid sick leave provision of the FFCRA, it entitles employees to use up to 80 hours of leave. And that leave provision is going to be based on what the employee's schedule is. So the employee, if the employee works up to 40 or more hours a week, they have an entitlement to up to 80 hours over a 2-week period. If an employee is scheduled to work 24 hours a week, then their eligibility would be for up to 24 hours over a 2-week period, up to 48 hours. So the leave is always going to be based on, the entitlements based on what the employee's schedule is. In some circumstances, you might have employees whose schedule varies and there's not an anticipated, a specific schedule. And in that case, what the employer can do is look back over a period of months. If the employee's been employed at least 6 months, the employer can look back over the 6-month period and make a determination of what the employee's average schedule is. And again, if it's up to 40, if it's 40 or more hours a week, then that employee's entitlement is going to be up to 80 hours. Or if that employee's average hours are less than 80 hours, then the leave entitlement is going to be based on what that average is for the weeks ahead. But that average determination, the employer only needs to make that determination if it's unknown what the employee's schedule is going to be. Otherwise, the employee is entitled to take leave from the schedule that they're expected to work, from the days they'd be taking leave, from the days and the hours that they'd be expected to work, but for the reason that they need paid sick leave under the FFCRA. And so next slide, please, the required rate of pay. So the employer is required to pay for the employees' paid sick time based on the highest wage rate. And that's either going to be, in most cases, that's going to be the employee's regular rate of pay. And by regular rate of pay, that's a term that we use when under the Fair Labor Standards Act, when you're talking about the employee's straight time rate. What's their regular rate of pay? And that is what they ordinarily are paid. The minimum wage, if they're paid less, if their regular rate of pay is less than the minimum wage, then the minimum wage is going to be the required rate. And if their rate of pay, their regular rate and the FLSA minimum wage rate are less than the highest applicable state or municipal minimum wage rate, then the highest applicable state or minimum wage rate is going to be the basis. So from the FLSA, so that's what we're starting with as far as what the required rate of pay, the highest applicable wage rate, and in most cases that's going to be the employee's regular rate of pay. Next slide, please. For the first 3 leave reasons, and those are the reasons that are affecting the employee, him or herself. So that's when the employee is under a quarantine order from the government, or they are under a healthcare provider's isolation order, or the employee is experiencing symptoms and seeking a diagnosis. In that case, the required rate of pay for the paid sick leave period is 100% of the employee's regular rate for the hours that the employee would be scheduled to work, up to 40 hours a week and up to 80 hours over 2 weeks. And I see we've got a question about who is included in an individual, as an individual. So yeah, so let's go to the next slide on the 2/3 calculation. So for those reasons 4 and 5, when the employee is needing leave to care for an individual subject to a quarantine or isolation order, or they're caring for their child because the school or the place of care is closed. In that instance, the required rate of pay is less than 100%. It's 2/3 of the applicable rate of pay. And when we're talking about an individual for this reason for leave, there's no requirement that that be a person that the employee has a particular family relationship to. So there's no test that there is a biological relationship, for example, or a marriage relationship. On the other hand, it is someone who the person would be expected to provide care for. So it would be somebody that the employee has a relationship with, where they are a person who's providing care to that individual and might be expected to provide care. So it's not so that there's not a strict rule on who that person can be, other than it's something other than a stranger, somebody that the person could have a relationship with where they're providing care. And I see there's also a question about the age of a child. And again, we'll talk about this again when we get to the expanded family and medical leave. The age of a child is for purposes of for purposes of being able to take leave for someone who's for a child. A child, the definition of child is the same definition that we use under the Family and Medical Leave Act. And that is a son or daughter of an individual who is either under 18 or 18 and older and incapable of self-care because of a disability. And a parent is under the, also following what we look at as a parent under the FMLA. That can be an individual who is a biological parent, a step parent, a person who is in loco parentis, who is providing the day-to-day care akin to a parent's to a child. So that is the definition of a child that the individual would be eligible to take the care for. Let's see. And I think that we're moving now to the next, if you want to move to the next slide, we're going to be moving now to talk in a little bit more detail about the Emergency Family and Medical Leave Expansion Act. And, but we can pause. I don't know if you want to take about 5 minutes for some more questions, David.
Move on to the next section because I'm afraid we're going to run out of time. We want to make sure you cover your
Gotcha. Okay, well, Helen, then let me let you take it away, and we'll get as many questions as we can at the end.
Okay, great. And I'll try to move through this quickly because I think we've covered a lot of ground already. So the basic provisions under the Expanded Family and Medical Leave Act include that an employee may take 2 weeks of unpaid leave plus 10 weeks of paid leave to care for his or her own son or daughter whose school or place of care is closed or whose child care provider is unavailable due to COVID-19 related reasons. For the initial 2-week period, the employee may take paid sick leave, or they can substitute any accrued vacation leave, personal leave, or medical leave under the employer's policy. For leave needed in the following 10 weeks, the employer must pay the employee at an amount that's no less than 2/3 of his or her regular rate of pay for the hours that the employee would normally have been scheduled to work. And let's go to the next slide. All employees, including full-time and part-time employees of covered employers, are eligible for expanded family medical leave if they've been employed by their employer for at least 30 calendar days. An employee is considered to have been employed by their employer for at least 30 calendar days if they've been on the payroll for 30 days immediately prior to the day leave would begin. And there's some special rules if employees were laid off or have been terminated on or after March 1st that we would just want to make mention of, that there is a special rule that applies there. So if you have employees who were terminated or laid off as of March 1st and then were rehired or reemployed before the expiration of the FFCRA period, December 31st, 2020, then there may be some eligibility here as well, and there's a special rule that applies around that. Moving to the next slide. Okay, so there is only one qualifying reason for leave under the expanded family and medical leave provisions, and that is to care for a child due to that child care or school closure related to COVID-19. The same reason as reason 5 under the paid sick leave provisions that Christine went over. Now, we've added some information to our guidance on our FAQs on our website recently that will help try to walk through some of these school-related issues as well. We specifically provide that if the physical location where the child is receiving care or instruction is now closed, then we consider that to be the school or place of care closed for purposes of this type of leave under either the paid sick leave or expanded family medical leave. It's true even if the instruction is still being provided online or through some distance learning or virtual format. If that physical location is closed, then it would be considered to be closed for purposes of the employee taking FFCRA leave. Additionally, if the school is operating on a hybrid attendance basis, maybe operating on an alternate day schedule where it's open one day and the next day it may be closed, but the children are expected to participate in distance learning. If that is the case, the school is effectively closed for the child on the days that the remote learning is taking place. So the employee would be able to take leave on those days. If, on the other hand, the child's school is giving the parent a choice between having the child attend in person or participate in a remote learning program, then the employee would not be eligible to take paid leave under the FFCRA because in that circumstance, the child's school is not closed due to COVID-19 related reason. It would be open for the child to attend and the parent's making the choice for the child not to attend in that instance. And the same thing is true if the school year is delayed in starting or is starting with a remote learning program, and we'll evaluate later into the school year about whether and to what extent they're reopening. If the employee's child, if their school is on a remote learning platform and it's physically closed, then the employee would be eligible to take leave under the FFCRA. Next slide, please. Okay, and as I mentioned previously, the first 2 weeks of the expanded family and medical leave are unpaid. The employee may elect to use existing vacation, personal, or medical or sick leave under their under the existing employer's policy, or they can elect to use emergency paid sick leave because this is a qualifying reason under the emergency paid sick leave as well. After that initial period of unpaid leave, the employee who's using this expanded family and medical leave would be paid for leave at 2/3 his or her regular rate of pay for the hours that they would have been scheduled to work. The 2/3 pay is capped at $200 a day or $10,000 in total for the entire period.
And Helen, can I just jump in real quick because we got this question a couple of times. So the paid sick leave under EPSLA, that is always paid in addition to the employer's accrued leave bank or leave policy. So an employer can't take credit for paying for paid leave under the EPSLA using leave in the employee's leave bank that they'd already accrued.
Hi, and this is Tiffany, wanting to ask a couple of those questions as well, since we're on this subject. How often can the employee take the paid leave? Does it have to be all at once, or can it be intermittent? And then what if they have several reasons for taking it? Can they only take it once?
So, and Helen, is it all right? I'll go ahead and
Yes,
jump
please,
in on that one.
please, jump right in.
So, thanks. So the leave can be taken intermittently. Generally, for leave to be taken intermittently, it needs to be with the employer's and the employee's agreement. So if you want to, let's say that your child is remote learning, and an employee is sharing the oversight, the care of the child with another person. So they ask the employer if they can only use leave 3 days a week. If the employer agrees, they could, both sides would have to agree for that to be used intermittently. The other situation can be if there is a leave need that begins and ends. So for example, before the person has used up all of their leave entitlements. So that might have happened, let's say the school the employee used some leave at the end of last school year and they still have 6 or 7 weeks of leave available, they can pick it up again. Or if the employee was caring for an individual and they only needed to use 4 days of leave, now they could pick up and take leave for another reason later on.
Thank you. And what about exempt employees? Is the leave 10 paid days rather than 80 hours, or how does that work for exempt?
Okay, so yeah, let me go back to, so when we're talking about the paid sick leave, if that's the 80 up to 80 hours, that is always, that's always paid as an additional leave benefit. That an employer can't use an employee's vacation time or sick time to cover that payment. On the other hand, when we're talking about the expanded family and medical leave, so there's the first 2 weeks are considered unpaid under the expanded family and medical leave. The 10 weeks that are paid, for that pay period, the employee can the employer can take credit and pay the employee through their vacation pay. If it applies to, they can require them to use accrued paid time off, and then also get credit under the FFCRA for providing that paid leave and apply for the tax credit through IRS if they're eligible. But the 2 weeks that are unpaid at the beginning of expanded family and medical leave, in that instance, the employer can give the employee paid sick leave under the EFMLEA, under the FFCRA at the same time. So if an employee has not used paid sick leave for any reason and they've still got an entitlement to 2 weeks of paid sick leave under the FFCRA, they can use that for those first 2 weeks that are unpaid under the expanded family and medical leave. So that, in which case, that would be, because it's the same leave reason, the child care not being available.
Great, thank you. I want to make sure we finish up your slides and get to the resources. So let's do that.
Sure, thank you.
And I think we're almost there. If we can go to the next slide. This is really just a point that we want to make, that the new expanded family medical leave provisions, this is a new leave reason under the FMLA. It does not provide more weeks. So an employee who's already used 12 weeks of leave under the FMLA would not be able to use the expanded FMLA leave. It is counted as part of the FMLA leave provisions. And next slide is our resource slide. We have a ton of resources available on our website, and we provide links here in the presentation slides where you can go to have questions addressed. I'll point out the Families First Coronavirus Response Act notice, frequently questions and answers, actually. The Response Act questions and answers, the third bullet there. We have we're up to 103 frequently asked questions that address a lot of what we have included in our presentation today. And it's a great resource if you haven't already checked it out. And I'll also point out specifically the final bullet, our email address for specific questions. I know we're up to close to 200, maybe more questions just from things that you all are putting into the Q&A box today. Obviously, we're not going to be able to answer every single question, but if you want to follow up with us, you can use that email address to contact us directly with your questions. That being said, there are a few things that I do want to just mention. I saw several inquiries about whether these provisions will be expanded beyond December 31st. We don't know. There have been some proposals in Congress that are still, and as far as I am aware, still under consideration, but whether Congress will pass any act to expand these provisions or write additional provisions for leave going into 2021 will be up to Congress. At this point, these provisions are set to expire December 31st.
Helen, and I would just add very quickly on the email, if you are emailing us, please put a phone number. We'd much rather be able to talk through your questions than give you an email response that may be incomplete.
Great, thank you. In the last few minutes, could we cover a couple of things about the in-school versus virtual learning? And for example, if DOL is DOL saying that a parent isn't eligible for EFMLEA if the school offers in-person option or virtual, even if a child or another person in the family is high risk for COVID? So what happens in that circumstance?
So I think that's pretty fact specific, and we would need to look at all of the individual facts to analyze whether leave will be available in that specific circumstance. We do address in our FAQs, and I believe it's 97 through 100 or 98 through 100, the different scenarios where a school may be open or have different options of attending or not attending. And one of those is specific to the scenario, and it does not bring into play if someone in the home is has COVID-19 or you know, there's direct concerns. But if the school is offering an option to parents of either attending school or in person or virtual, then in that instance, the school is not considered closed, and FFCRA leave is based on that school being closed. And again, Christine, happy to have you chime in as well.
Sure. And that first rule, though, if the school is not open to the child and they're saying that your child's school today is virtual learning only, or this half of the day, that is considered closed for purposes of the FFCRA eligibility. It's when the employer says to the parent, the school is open, your child can come in, but we're offering as an option online instruction. And that's the case where we're saying, well, if the employer has an option, the employee has an option, then the FFCRA is not available for leave. And then if there are issues with individuals in the home who are at risk and they're quarantined, or they're under a doctor's order and they need care related to their being quarantined, then the employee may be eligible to care for the individual under the paid sick leave provisions of the FFCRA.
Great, thank you. I think we're about up on time, so I'm going to turn it back to David for closing statements.
Thank you. As you see on the Q&A, we have 200. We had 200 come in registration. So there is a lot of inquiry, a lot of interest here, and a lot of confusion. But I want to make sure we all appreciate, we'll do a virtual clapping for Helen and Christine for going out of their way to answer the questions, to be as supportive as possible. And I want to repeat the phone number that Christine said, the 1-866-4-US-WAGE, which is 1-866-487-9243. That's for the immediate, to find your regional wage and hour division. And I have found in my experience that they are always forthcoming and eager to help. Thank you, Helen and Christine. Thank you, Department of Labor, for writing and updating the materials. September 11th is when new guidance came out, and September 16th is when the new regulations took effect. So the law is evolving, because everything in this pandemic world is evolving. So we have the opportunity to learn and get up to speed and comply. After the presentation's over, we will be sending to all who registered the recording of this, a link to the Department of Labor slides, because they will always be updated, and those will be clickable, I believe. The links will be available there. We'll also put that phone number that I mentioned in the email as well. But thank you so very much for joining us. Thank you for working to achieve full compliance. And one more time, thank you, Helen Applewhite and Christine, for joining us and being so helpful. Thanks,
Thank you so much, David, Tiffany, Rick, and to everyone in the audience.
Bye all.